everyone for virtual SSLT. I think all of you know our speaker today, Sandy Steele, so I don't really have to introduce him. We've got a 2-hour slot for our session. So Sandy said he would aim to speak to us for about 30 minutes, and then we'll open the floor for discussion after. The title of the paper is Liability for Permissible Harm, and I'll hand over to Sandy now.
Okay, thanks very much to Tim for the invitation to be back at the Singapore Legal Theory Symposium, and also to Suguna for organising the recording. I'm going to go straight in. So in this paper, I'm trying to answer 3 questions, which I've put on the handout. The first question is, are there examples in the law of non-contractual duties to compensate in the absence of, all things considered, wrongful conduct in the common law, mainly in English law? I'll say a word about what I mean by all things considered in a moment. The second question is, does the law adopt a consistent approach to these cases of, so I'm going to say there are such examples, but does the law adopt a consistent approach to compensation in these cases? And thirdly, are there good normative justifications for compensation in the absence of wrongful conduct? All things considered wrongful conduct. So just to spoil the anticipation, my answers to these 3 questions are, on the first one, yes. The second one, no, the law doesn't adopt a consistent approach to them. And thirdly, yes, there are good normative justifications. And I'm trying, I guess the part of the paper I'm still thinking about is the final part about normative justifications, but I have some thoughts on that which I will share with you. Okay, so why is this of interest? Why ask these questions? So I think there are at least 3 reasons. Firstly, part of the self-presentation of the law of torts, and indeed a lot of the academic theorization of the law of torts, presents it as a law of wrongs. And if we have cases in which we have liabilities and duties to compensate in the absence of all things considered wrongful conduct, there's at least a question raised about, at least we have to think, well, in what sense is tort law about wrongs or wrongdoing? If we have these cases which are classified, at least some of them that I'm going to talk about are normally classified within tort law, of liability in the absence of all things considered wrongdoing. It might be there's still a sense in which tort law is about wrongs, but at least if there are these examples, we need to think perhaps more carefully about exactly in what sense tort law is a law of wrongs. Secondly, I think these cases are morally puzzling, at least some of them are. So in some of these cases, it's not only that it's permissible to harm another person, it's also, in some of the cases, morally required. So why would it be the case that morality is requiring you to pay compensation for harm that it's requiring you to impose? On the face of it, this seems like a rough deal. Morality is saying you must inflict this harm, but also you must compensate for it. Even in the case where the harm infliction is permissible, I think there's still a slight puzzle about why we might think there's a requirement to then compensate. If morality is giving a green light to the infliction of the harm, why then think that after the harm has been inflicted, it needs to be repaired? So there's a moral puzzle. A third reason is that more doctrinally, there's been a lot of attention in the literature on one case, Vincent and Lake Erie, which is a very fruitful and interesting example. But I think there's a wider range of cases that it would be useful to consider in thinking about permissible harm, which haven't received so much attention in the literature. So there's a wider range of legal examples of this, of what I would say is a similar or the same phenomenon. And it's useful to think whether the law is adopting a consistent approach across this range of examples. And to my knowledge, that question hasn't received so much attention in the literature because of the focus on this case of Vincent and Leakiri. Okay, a couple of clarifications before getting into the answers to the questions. First clarification is I'm talking about moral permissibility. So some of the examples, the harm inflicted will be legally permissible, some not, and somewhere it's maybe not clear what the law's position is on the issue of permissibility. But the reason I'm talking about moral permissibility is because I think that's the source of the puzzle. Why is it that we could have moral duties to compensate and moral liabilities to compensate when morality is either requiring us to inflict harm or permitting us to inflict harm? I draw a distinction between all things considered impermissible and pro tanto impermissible. So an action is pro tanto impermissible if there's a reason against doing that action which is defeasibly sufficient to make it all things considered impermissible. And it's all things considered impermissible if there's an all things considered duty not to do that action. So this focus on moral permissibility raises an obvious concern that I'm just going to be sharing my subjective opinions about what's morally permissible with you. But I think I've picked a range of examples in which most moral theories would converge on the permissibility of the harm. Really, the only people I think who would disagree with most of the examples of permissible harm are those who have a kind of absolute deontology, that they think that if you have a right, it can just never be permissibly infringed. So I guess I find that view very implausible, but I'm not arguing for it in the paper. I guess the paper is directed to people who don't have that view, and see what progress we can make from within that shared perspective. A second distinction is between fact relative or objective permissibility and evidence relative subjective permissibility. Objective and subjective is a little bit misleading, but fact relative permissibility is when the facts as they are in the world entail the conclusion that the action is, all things considered, permissible. Evidence relative permissibility is when the facts as they would appear to a reasonable person in the position of the agent entail the conclusion that the action would be, all things considered, permissible. I'm looking at both categories of case in the paper, and some of the arguments hinge upon this distinction. Okay, so let me move to the first question, examples. So here are some examples of liability or duties to compensate for permissible harm. First one, the well-known one, compensation for intentional and known side effect invasions of rights. I'll maybe get to the known side effect point later, but compensation for intentional invasions of rights justified by private necessity. So roughly speaking, here we're talking about cases in which A intentionally violates B's right in order to protect some interest of A. So A is acting for A's to protect A's own rights in infringing or violating another person's rights. And so that's normally how Vincent and Leakiri is characterized. So in Vincent, A damages B's dock in order to protect cargo on a ship and the ship itself from destruction. And the court in Vincent and Leakiri said that was justifiable to do that. But nonetheless, they had a duty to pay compensation for damage caused to the dock. Contrast the compensation which is payable in cases of private necessity with public necessity. So public necessity, again, roughly, is where A violates B's rights in order to protect the rights of C, or someone other than A, would be more accurate. And the law there says there's no duty to compensate. Or maybe it says there's no liability to compensate. Common enemy rule. So again, contrast the duty to pay compensation in the necessity cases with the common enemy rule. So this rule states that, so it's a rule which applies in private nuisance. If adjoining landowners face a common threat to their land, so if we call them A and B, A is permitted to take steps to protect A's land from a threat by diverting that threat to B's land, in circumstances where that A might well know that that's going to cause physical damage to B's land, but nonetheless, A is permitted to do that in law, and A isn't under a duty to pay compensation. So the structural similarity with private necessity is that A is doing something for A's own benefit, which A knows will damage B, but the difference is no duty to compensate in these cases. We got a very similar rule for private necessity cases in German law, which makes clear that, well, in German law, you have the duty to pay compensation even if you're saving your own life. So unlike in Vincent, which is property being sacrificed for property, in German law, and I think the US position, insofar as it can be ascertained, would agree with this, is that even in cases where you're acting to save your own life, you have a duty to pay compensation. Is this really morally permissible harm, the private necessity cases, all things considered morally permissible harm? Well, I think we just have to make it's not always going to be morally permissible, all things considered, to damage another person's property to save your property. But if we make the stakes high enough so that you're damaging another person's property to save your life, it just seems difficult to accept that, if we make the property damage low enough and we think about the value of human beings' lives, that you could be required to sacrifice yourself to save someone's can of Coke. Human beings are just more valuable than tangible objects. Secondly, compensation in cases in which a court refuses an injunction, in cases involving interference with a property right. So as I say in the paper, there are lots of reasons why courts might refuse an injunction. Some of them have nothing to do with the permissibility of the defendant's conduct. Some of them might be just to do with undue delay in bringing the claim. Culpability type arguments. But one set of cases, I think, does refuse an injunction because the court is of the view that the conduct is permissible, and ought to continue. So Denison Ministry of Defence is a good example. Some RAF jets are flying across the claimant's land. They're very noisy. They constitute a nuisance, but the judge refuses to grant an injunction because it's in the public interest, he holds, for this training program to go ahead. So the public interest clearly demands that RAF Wittering should continue to train pilots, and damages are awarded in lieu. Moving on now to cases of evidence relative permissibility. So when a person is seeking pre-trial to get an injunction to prevent a possible violation of their rights, the normal practice of the courts is to insist upon an undertaking being given to compensate in the event that the injunction is unjustified relative to the facts or the law as found at trial. So in these cases, I might get a pre-trial injunction on the basis of an entirely reasonable belief that someone is about to violate my rights. The court will insist, though, that if it turns out that the conduct of the other party isn't a violation of my rights relative to the facts, that I have to pay compensation to them for the loss that's caused by the imposition of the injunction. You might say, isn't it just the undertaking which justifies the compensation here, the fact that you promised to pay compensation? But as I say in the paper, the courts clearly think it's justifiable to insist upon an undertaking being made here in order to get access to the injunction. So they seem to think that there's independent reasons for the person to compensate in these cases, and the undertaking is just reinforcing those reasons. Okay. Compensation for mistaken but evidence justified punishment. So you're convicted. It was entirely reasonable for the court to think you're guilty. Most legal systems, well, I'm not sure if it's most, but certainly some prominent legal systems impose a duty to compensate upon the state there. It's limited in various ways in English law, but there is, in a category of cases, a duty to compensate. So again, it was reasonably, there was a reasonable belief that there was a justification for harming someone by imprisoning them, convicting them. But nonetheless, there's a duty to compensate which arises. Finally, there's a category of compensation for harm inflicted on the basis of a reasonable belief that a justification exists. So in self-defense cases, if you have a reasonable belief that there are facts which would justify you acting in self-defense, and you inflict the harm, it seems the current law is that you don't have a duty to compensate. And that pattern is reflected across some other cases about reasonable belief in justification for an arrest, reasonable belief in the lack of capacity in the context of a trespass claim, detention of a person on the basis of a reasonable belief that they're mentally disordered, reasonable belief that a publication is in the public interest. And in each of these cases, there's no duty to compensate. But if you contrast that with a reasonable belief that someone permits you to use their stuff or possibly to interfere with your person, so waiver or consent, there is a duty to compensate even if you have a reasonable belief in these cases. So if I convert your goods, reasonably believing that you permitted me to do the act which constituted the conversion, nonetheless there's a duty to compensate. Okay. So these are my examples of compensation for permissible harm. Some of them involve fact relative permissibility, some of them just involve evidence relative permissibility, but the harm is fact relative impermissible. Consistency. So take the contrast between private and public necessity first of all. So there's two justifications normally given for this distinction. One is an incentives argument, and the other one is a kind of fairness argument. So the incentives argument is just that we need a public necessity defense in order to not to discourage altruistic interventions, which would protect people's rights. So if I know that I'm going to be sued if I intervene to damage someone's property, or I know that I can be sued if I damage someone's property in order to save the lives of 10 people, maybe that will make me think twice about intervening. And I actually find this argument relatively persuasive in legal systems where there's no mandatory insurance in these sorts of cases, and in circumstances in which it's unlikely that people will take out insurance. I think just the risk that people won't intervene in these cases is significant. So I think there is a good incentives reason for the distinction. But what I suggest later in the paper is that there might be a more fundamental moral distinction between the two, and that before we even get to thinking about should the law enforce some moral duty to pay compensation in these cases, what I'm saying later in the paper is maybe there isn't really moral duty to pay compensation in the public necessity cases. So it could be that if someone has a moral duty to compensate, there's good reasons for the law not to get involved because of the bad consequences of doing so. But what I'm suggesting later in the paper is that even at that earlier, more foundational moral stage, there might not be a moral duty to compensate, which the law can latch onto at all in the public necessity cases. So I'll come back to that more foundational point later on, but just to put on the table that I find even if I think the law has a plausible justification for drawing the distinction. Secondly, public necessity versus compensation in lieu of an injunction. So the common thread here is that between these two situations is that A damages B's right, but the damage being relatively small is justifiable for public good reasons. So in the public necessity case, no duty to compensate. In the compensation in lieu of an injunction, there is a duty to compensate. So there's a narrow reconciliation possible here if we just focus upon Denison, the Ministry of Defence. So in Denison, the Ministry of Defence, you have the state damaging someone in order to serve a public interest. And you might think when the state's imposing a harm for the public interest that it's more like a private necessity situation in a sense, because you have one person, the state, inflicting a harm for the state's own interests. And so although it looks like a public necessity case, it's really like a private necessity case because the state is acting for a state interest. But if we go beyond Denison, Ministry of Defence to other cases, it seems that the law will refuse or it could refuse an injunction where someone is acting partly for a profit-making motive and partly for a public interest reason. So here there looks like there's a greater conflict with public necessity because it's possible for the public necessity defense to arise when you're acting both for your own interest and for the interests of another person. So in some of these compensation in lieu of an injunction cases, you've got someone who's acting both for their own interest, for a profit-making interest, and there's a public interest in what they're doing. And there the conflict with public necessity looks more stark because there are some public necessity cases which seem to have that structure. So the tentative reconciliation I suggest in the paper is that in the compensation in lieu of an injunction cases, the primary motive is a profit, often, at least the cases in which this has arisen, the primary motive is a profit-making motive, and the public interest is a kind of an incidental thing. So why would that matter? Well, I don't think you have the same incentives-based problem in these compensation in lieu of an injunction cases, because the defendant can essentially price in the cost of compensation into their business model. So where they're acting for a commercial purpose, there's less of the incentives argument has less force, I think. It may also be significant that they're also acting predominantly for, so at the moral level, it might be significant that they're acting predominantly for their own gain, and the public interest is a kind of incidental side effect of what they're doing. Okay, consider now the contrast between private necessity and the common enemy rule. So the common thread here is that A causes damage to B's right in order to protect A's own good. And in one case, we've got a duty to compensate. In the other, we don't. So a couple of contrasts, a couple of distinctions that might be raised to defend the law here are the difference between intention and intentional harming, and harming as a known side effect of one's action. So you might say in the Vincent Leakiri case, they intended to cause the harm to the dog, whereas in the common enemy cases, what you intend to do is to protect your own land, and it's a known side effect that you'll damage someone else's land. But interestingly, I think, you know, in Vincent, you could say the same thing. It's a known side effect of what they were doing, that they would cause damage to the dock. It wasn't their aim to cause damage to the dock in Vincent Leakiri. They knew that when they anchored the boat to the dock, that it's possible they knew that it would have this effect, but it wasn't their aim to damage the dock. It was the storm thrusting the boat against the side of the dock which caused the damage. So you could say the same thing about Vincent and Leakiri, that it's just a known side effect case, but the law has taken the view there that there's still a plausible case for a duty to compensate. A second contrast is between using something as a means versus not. So in Vincent Leakiri, or in the private necessity cases, you might think someone is using another's thing as a means of self-protection, whereas in the common enemy cases, you're just building a wall on your land, say, and that deflects floodwater onto your neighbour's land, but you're not using your neighbour's land as a means of self-protection. But again, you could say the same thing about Vincent and Leakiri. They're not, the damaging in that case wasn't a means of self-protection. It would have been possible for them to protect themselves even without there being damage to the dock. Their aims could have been entirely successful even without damaging the dock. And even if you reject those points, it's just not obvious why the distinction between intention and side effect, or using as a means and not using a means, should have this moral significance in this context. So if you accept there is a moral distinction between intention and known side effect, and using as a means, you think that has some moral significance, it's not obvious that it has enough or such moral significance as to justify a difference between a duty to compensate and not. I raise a possibility in the paper about whether there's a distinction in terms of the common element of common enemy is important, but I suspect I don't have time to go into that here, but there's some discussion of that in the paper. But as the law stands, I think there's a difficulty in reconciling these two doctrines. Okay, I'm going to move on to justifications so that I can get some of that on the table as well. So in the final section of the paper, what I'm trying to do is to assess whether there's any good justifications for duties to compensate in the absence of all things considered wrongdoing. And ultimately, what I come up with is to say that there are potentially multiple justifications of doing so, but I try and make some critical remarks about some existing attempts to explain duties to compensate in these cases. So basically consider three views. One is what I call conditional permissions. Well, primarily consider three views: conditional permissions, rights, and what I call the benefit principles. So let me just say a few things about each of these. So conditional permissions, the idea here is that sometimes the permissibility of an act hinges upon compensation being paid afterwards. And this is one way of interpreting what Boland was saying in an old article in the Harvard Law Review from the 1920s. So the thought is in Vincent and Leakiri that in some sense the permissibility of damaging the dock comes with the condition that it's only permissible if you pay compensation afterwards. So I have two difficulties with this. So I don't reject this entirely as an explanation of what's going on, but two difficulties at least that apply to at least some cases. The first one is one of analytical fit. Is this really the normative structure of these cases? So in Vincent and Leakiri, if we take a modified Vincent and Leakiri where you damage the dock in order to save your life, is it really true that if you don't pay, if it's impossible to pay compensation after the fact, that you would be committing an all things considered, you would be behaving all things considered wrongfully in the circumstances? So if it was all things considered wrongful to damage the dock and then not pay compensation, it would seem to follow that you ought not to do that. And so if we imagine a hypothetical judge standing dockside, it would be, you might think it would be okay for them to issue an injunction to say, don't damage this dock if we know that in the future you're not going to pay compensation. But that just seems like the wrong conclusion to me, that a human being ought to sacrifice their life to save a dock if they know they're going to not pay compensation in the future. Again, that just seems to place rather too great value on commercial docks to my mind. But I think there are some cases where this looks like a more plausible fit, that in the compensation for interim injunction cases, we might think that the permissibility of stopping someone's activity might well be contingent when it's the permissibility of stopping someone's economic activity might well be contingent upon compensating them after the fact in those sorts of circumstances. But I think a more fundamental problem with this view is that it doesn't really give us a normative explanation of why the permission is conditional in the ways supposed. So we need some kind of explanation as to why the permission to act in self-defense, say, isn't normally conditional upon paying compensation, or if I'm right about the difference between public and private necessity cases, why it's only conditional in private necessity cases but not public necessity cases. So in and of itself, saying that the permission is conditional doesn't really give us any normative explanation of when the permission is conditional in this way or not. We need some deeper explanation of this. I then turn to the rights view. So this is a view which is associated with Judith Jarvis Thomson and Joel Feinberg. So in my formulation of it, A has a duty to compensate B for harm which A permissibly cause B just when and because A has infringed a non-forfeited, non-waived right of B. So this looks like it has a good fit with a lot of the legal cases, notably Vincent. And you might think it's got some normative plausibility in that the explanation it gives for duty to compensate is that although your conduct was all things considered permissible, you still infringed someone's rights. You still interfered with someone's rights, and that gives you a distinctive reason a pro tanto duty to compensate the person. So the difficulty I have with the rights view is not that it's got an implausible conception of rights. So I have a discussion in the paper about the difference between input and output versions of moral rights, and this view relies upon a non-specificationist view of rights, which I think is I think that aspect of this view is fine. The difficulty I have with it is it's fit with intuitions, I suppose. I think when you consider a wider range of cases, it's less obvious that this gives you the intuitively correct results about certain cases. So if you think about the Storm 2 examples, this is another variation on Vincent, where you have an altruistic intervener. So C, a stranger to B and A knowingly damages B's dock by anchoring A's boat to B's dock in order to preserve unconscious A's life. Anchoring to B's dock is the only means by which C can preserve A's life. So here we have some third party who damages the dock, knowing in order to save the life of a person, knowing that doing so is going to cause damage to the dock. Or I give a simpler example on the handout. Imagine that the only way of saving a child from a car that's running down a hill is to put an umbrella under the car. You have to take someone else's umbrella, and you know that it's going to damage the umbrella. Do you have to pay compensation? So you've infringed a right here. You've infringed the property right in the same way you have in the Vincent case, but you've done so entirely for the benefit of another person, not for your own benefit. And here it seems to me pretty rough intuitively to think that you have a duty to pay compensation. So it's not the source of the intuition isn't that you're not to blame here, because you're not to blame in the Vincent case either. The source of the intuition is in some sense that you're acting entirely for the benefit of another person here other than yourself. So it would be good though to have a deeper explanation of why that intuition, of that intuition, I suppose. Why is it the case that the rights principle goes wrong in these cases? So I can think of two explanations. One of them is that in cases in which there's a moral requirement to inflict the harm, so in the Storm 2 case, if the costs of the stranger of intervening are really low, my view would be you have a moral requirement to inflict the harm. And if you're morally required to inflict the harm, you might say, well, there's just no choice of the matter. Whereas in Vincent and Lake Erie, you might say you're not morally required to damage the dock to save yourself. You could allow yourself to die. You're not morally required to save your life in these cases. So that you might say there's a difference between being cases in which morality is requiring you to do something and cases in which you're just choosing for reasons of self-interest to do it. But I think if the concern is choice here, that you're that the thought is that when you choose to impose harm upon another person, that generates a duty to compensate. In both cases, it seems to me you've got no choice but no real choice but to inflict the harm. So whether the source of the lack of choice is morality or self-interest, in both cases you've got no real choice but to inflict the harm. Also, if you accepted that that was the distinction here, you would get a quite strange result, I think, that in cases of supererogatory harming by the third party, so there wouldn't be a moral requirement to inflict the harm in the supererogatory cases, but then the supererogatory harmer would have a duty to compensate. So you would have supererogatory altruistic interveners have to compensate. Required interveners do not have a duty to compensate. So the moral saint or moral hero has to pay compensation for what they do, but the morally required person doesn't. That seems like an odd implication of this view. So a second explanation, which I find more attractive, is that when the cost to the person whose property is damaged or whose rights are interfered with are low, the intervener just imposes a cost upon that person, which the person has a duty to bear. So they have a duty of easy rescue to bear that cost for the benefit of the third party. Now that's also true in Vincent. So in the Vincent case, you have a duty to allow the person to use the dock once they at least get onto the dock. You can't just thrust them off. You have a duty to allow them to use the property. So that doesn't give us a distinction between the two cases. But in the Vincent case, the person has damaged the dock. So I concede in the paper that when you damage another person's rights, you've got a reason, a distinctive reason to compensate them. You also benefit in the Vincent case. So that distinctive reason you have is strengthened by the fact that you've benefited from harming the other person. So in the Vincent case, you get the reasons for compensation sort of stack up in a way in which they don't in the public necessity cases. You've got the reason to compensate, which is constituted by your distinctive role in damaging the person's rights, but you've also benefited from that. So those reasons, so the fact that you benefited strengthens the reason you have to compensate in such a way which it may well create a duty to do so. But that's not true in the public necessity case. So although you're distinctively involved, and you've got, you should feel maybe agent regret in having caused the harm, and you're distinctively connected to the harm in a way in which bystanders are not. Because you're only inflicting a harm which the person has a duty to bear, I think that's what prevents you having a duty to pay compensation for the harm. You've got a reason to do so, but you don't have a duty to do so. So that would be my attempt at an explanation of the distinction between the public and the private necessity cases at the moral level. And so that leads me to something like a distinctive ground of duties to pay compensation being this right benefit principle that I've put at the bottom of the handout, that you're under a duty to pay compensation for fact relative and evidence relative permissible harm if your right justified the permission. So in that sense, that constitutes your sort of distinctive involvement in the the right benefit principle really is two distinct things, which I should really separate out in some future version of this paper. One of them, one idea is that when you cause an infringement of another person's rights, you've got a distinctive reason to compensate the person, but it's not normally a reason if it was a justified infringement for the benefit of a third party, which creates a duty to pay compensation. But in cases where you benefit from the harmful infringement of another's rights, that does amount to a duty to pay compensation. But there's another idea, which is an entirely agency independent idea, which is a kind of, which some people would describe as an unjust enrichment type idea, that if your rights were what justified the interference, so if your rights grounded the permissibility of the interference, and you actually benefit from the interference, there's a kind of fairness argument that you ought to pay compensation independently of whether you've done anything. So the beneficiaries of, if we imagine the Storm 2 case, the unconscious beneficiary, I think has a reason of fairness to pay compensation, because it was their interest which justified this exceptional permission to invade another person's rights. If your interests play that kind of role in justifying this exceptional invasion of another person's rights, I think there's a fairness case for you compensating. So as I say in the paper, the kind of quid pro quo for the permission to invade another person's rights in this exceptional way is compensation. Okay, I'll stop there. I'm sorry I went over and